Hello, welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to discuss the important issues appearing in the New Delhi edition of the Hindu newspaper dated 19th December 2019. The news to be discussed has been presented on the screen, and timestamping for the same has been provided in the description box below. So let's start our today's discussion. The first news appears on page number 1. It says, "No stay on Citizenship Act implementation," says Supreme Court. The court says that it will hear all the 59 petitions filed in the Supreme Court on 22nd January. So, amid this ongoing protest in the entire country against this Constitution Amendment Act of 2019, which was recently passed by the Indian Parliament, various petitions were filed in the Supreme Court of India, whereby it has been contended that this particular act, that is the Citizenship Amendment Act of 2019, is against the secular principles enshrined in the Constitution. And this is contended that it is against the secular principles as enshrined in the Indian Constitution because this particular Amendment Act aims to provide citizenship based on religious identities to those illegal migrants from 3 different countries. So, the Citizenship Amendment Act of 2019 gives citizenship to those illegal migrants who have entered India on or before the 31st day of December 2014. So, there is a cutoff date as mentioned in Citizenship Amendment Act of 2019 with respect to granting citizenship to such persons or such illegal immigrants who have entered India. And this citizenship shall be granted to person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from 3 different countries, namely Afghanistan, Bangladesh or Pakistan, who have entered India on or before 31st day of December 2014. Further, this act will also provide citizenship to those persons who have been exempted by the central government under Passport Entry into India Act of 1920 as well as under Foreigners Act of 1946 from being declared as illegal migrant. So the petition filed in the Supreme Court contends that this particular provision violates Article 14 of the Indian Constitution based on right to equality. However, as of now, the Supreme Court of India has refused to stay the implementation of Citizenship Amendment Act 2019. However, the Supreme Court has rather orally suggested to the government to tell to the public about the real intention of this act so that there is no confusion among the public about the aims and objectives of Citizenship Act of 2019. Now, the government has maintained that the amendments made to the Citizenship Act of 1955 were meant to protect and welcome religiously persecuted people fleeing the 3 neighboring countries where Muslims forms the majority, and this was why Muslims were excluded from this act. So, the central government says that there is a particular reason to exclude Muslims from these 3 countries from granting citizenship. And the reason is that Muslims forms majority in these 3 countries, namely Afghanistan, Bangladesh or Pakistan. So the Supreme Court in this regard has issued a formal notice admitting 59 petitions filed by people from all walks of life and faiths, and the court said that it will hear the petition on 22nd January. So as of now, this petition is in court and the matter is sub judice. So let us wait for the final order of the Supreme Court. Now, this is an ongoing topic, and you will see various articles and editorials as well as news with respect to Citizenship Act as well as various protests going around the country. So, we have to focus on those issues which are important for us, both from prelims as well as mains perspective. So, in your prelims, this topic forms a part of Indian polity and governance, and in your mains, it becomes an important aspect of GS paper 2 with respect to Indian Constitution, as citizenship is a part of Indian Constitution as well as with respect to welfare schemes for the vulnerable sections of the population by the center as well as laws for such incidents. So this particular news with respect to petition in Supreme Court is a news in transition. So let us wait for the final judgment of the Supreme Court. The next news also appears on page number 1 and also appears as a continuation on page number 12. It says the GST Council votes for 28% GST on all lotteries. Now, as of now, there is a dual rate which exists with respect to GST tax rate on state-run lotteries as well as on state-authorized lotteries basically run by private players. The state-run lotteries are taxed at the rate of 12%, whereas the state-authorized lotteries run by private players as of now are taxed at 28%. So, as per the decision of this council, this dual rate with respect to state-run lotteries and state-authorized lotteries has been made uniform at the rate of 28%. And this uniform rate of 28% on both state-run lotteries and state-authorized lotteries run by private players shall become effective from 1st March 2020 as per the decision of the council. So after understanding the uniform rate of lotteries, let us also go through some of the other decisions taken by the council as well as certain basic facts about the GST council itself. Now the council has increased the GST rate on woven and non-woven bags and sacks of polyethylene or polypropylene strips or of the same likes. And this also includes such bags which are laminated or not laminated. And this rate has been increased from earlier or from present 12% to an increased rate of 18%. And this increased rate of 18% on woven and non-woven bags and sacks of polyethylene or polypropylene strips shall become effective from 1st January 2020. Now it highlights that this flexible intermediate bulk container or bulk bag is an industrial container made of flexible fabric that is designed for storing and transporting dry, flowable products such as sand, fertilizer, granules of plastics, etc. So basically these plastic bags which carry sand, cements, etc. shall become expensive as GST rates will be charged at a higher rate of 18% on these bags. Now, with respect to other decisions of the council has also agreed to constitute a grievance redressal committees at zonal as well as at state level, as these committees will address grievances of specific as well as general nature of taxpayers both at the zonal level as well as at the state level. And these grievance redressal committees shall comprise of both CGST, that is Central GST, as well as state GST officers, and will also include representatives of trade and industry and other GST stakeholders. So the council has agreed to constitute a grievance redressal committee to address various grievances of either specific or general nature of taxpayers at the zonal as well as at the state level. Now this becomes an important development with respect to addressing the grievances of taxpayers at large. Now, along with this, various states also expressed their concern with respect to declining tax revenue of the states, specifically with respect to GST collections. And it was on this regard that a presentation was made at this council meeting with respect to issues of revenue, GST rate structure, as well as compensation needs of the states. However, some of the states expressed their concerns with respect to this compensation needs with respect to GST collections. Now, another important point to be highlighted is that in the first 8 months of this financial year, only about 50% of GST collection targets have been achieved, and only 60% of compensation cess collections targets have been achieved. So these collections also reflects a declining tax revenue of the government both at the central level as well as at the state level. And as mentioned, on these lower tax collection, various states have expressed their concern and have asked for further cooperation from the center. So all these aspects were discussed during the 38th GST Council meeting, which was chaired by the Union Finance Minister Sri Sitharaman. Now, with respect to GST bill, it was introduced in the Parliament as 122nd Constitution Amendment Bill. However, it was notified after being passed by both houses of Parliament as 101st Constitution Amendment Act of 2016. And after this amendment, it provides for Article 279A, which says that GST Council shall be a joint forum of both center as well as states. Now, it becomes important to know about the 101st Constitution Amendment Act, as a question has been asked by UPSC in the mains of 2017. The question was, explain the salient features of Constitution 101st Amendment Act of 2016. Do you think it is efficacious enough to remove cascading effect of taxes and provide for common national market for goods and services? And you had to answer this in 250 words, as this question was of 15 marks. So, in this backdrop, the Constitution 101st Amendment Act with respect to GST becomes an important topic for us to understand from our examination perspective. So, as for Article 279A, it says that GST Council shall be a joint forum of centre and states and shall consist of the following members: the Union Finance Minister as the chairperson, the Union Minister of State in charge of Revenue or Finance as member, as well as the Minister in charge of Finance or Taxation or any other minister nominated by each state government as members. So, these are the members of GST Council. And it shall be the duty of this particular council to make recommendations both to the union as well as to the states with respect to important issues related to goods and services which may be subjected or exempted from GST, model GST laws, principles governing place of supply, threshold limits with respect to tax, GST rates including floor rates, special rates for raising additional resources for the government during natural calamities or disasters, as well as the council can give recommendation with respect to special provisions for certain states. So the council is empowered to make recommendations on these following grounds. Now, with respect to constitution of quorum of GST Council, it says that one half of the total members of Goods and Services Tax Council shall constitute the quorum at its meeting. So the quorum has been fixed at one half of the strength of GST Council. Now, every decision of the council shall be taken at a meeting by a majority of not less than 3/4 of the weighted votes of the members. And of this voting process, the central government shall have a weightage of 1/3 of the total votes, whereas votes of all the state governments taken together shall have a weightage of 2/3 of the total votes cast. So overall, the center have a total weightage of 1/3 of the total votes, whereas all the states together have a total weightage of 2/3 of the total vote. And every decision at the council shall be taken by a majority of not less than 3/4 of the weighted votes, including that of center as well as that of states. Now, another important point to be mentioned is that the GST Tax Council shall establish a mechanism to adjudicate any dispute between Government of India and one or more states, between Government of India and any state or states on one side and one or more other states on the other side, and between two or more states, as stated by the recommendations of the Council. So accordingly, the GST Act under Section 109 has provided for Goods and Services Tax Appellate Tribunal. So these can be said to be some of the important features of Constitution 101st Amendment Act of 2016 with respect to Goods and Services Tax Act. So this topic becomes important both from our prelims as well as from our mains perspective. With this, let's move on to our next news discussion. Next news appears on page number 10 in the article section. It says, Trump cards in the impeachment deck. The process to pin down the US president could be politically wasteful for the Democratic Party. Now, this article has tried to explain the political situation with respect to impeachment of US President Donald Trump. However, as per recent reports, it has appeared that the House of Representatives of United States has already impeached Trump. So, in this news analysis, let us understand the entire process of impeachment of Donald Trump as compared to the impeachment process of Indian president. As you can see, This also forms part of GS paper 2, specifically with respect to comparison of Indian constitutional scheme with that of other countries. And in your prelims examination, this topic specifically with respect to impeachment process of the President of India becomes part of Indian polity and governance. Now in India, we have the Lok Sabha as well as the Rajya Sabha. Lok Sabha is the lower house of the Indian Parliament, whereas Rajya Sabha is the upper house of the Indian Parliament. Similarly, in United States, they have the House of Representatives, which is considered the lower house of their parliament, also referred as US Congress, whereas Senate is their upper house. Now, the entire process of impeachment of the President of United States is only restricted in the technical terms to the House of Representatives. Whereas the process of impeachment for the President of India pertains or is a combined process of both lower house as well as that of the upper house. Another important point to be noted is that the impeachment process for the President of United States begins only in House of Representative, that is the lower house, and cannot begin in the Senate. Further, the process of impeachment has to be passed in House of Representative by a simple majority. Whereas, with respect to the President of India, if he has to be impeached, then it must be passed by two-thirds of the total membership of the House in both houses of the Parliament. Further, the impeachment process for the President of United States, as already mentioned, is restricted only to the House of Representatives, and the moment it gets to the Senate, then it becomes a removal process. So after understanding some of these basic differences with respect to impeachment process of President of India on one side as well as President of United States on the other hand, let us go through this entire process of impeachment for the President of United States and also specifically with respect to Donald Trump. So the US House of Representatives, that is the lower house, has impeached President Donald Trump on charges of abuse of power as well as for the charge of obstruction to Congress. And this abuse of power pertains mainly to his phone call to the newly elected president of Ukraine. So let us go through this question answer format in order to understand the impeachment process of United States President and also why Donald Trump was impeached. It says that why impeachment? It mentions that founders of the United States Constitution feared that the presidents of the US could have abused their powers. So in order to shield their entire democratic process, they included this concept of impeachment of the President of United States in the constitution process itself. So it says that the founders of US feared presidents abusing their powers, so they included in the constitution a process for removing the president from his office. The next question is, what is the criteria for the impeachment? It says that the president under the constitution of US can be removed from office for treason, bribery or other high crimes and misdemeanors. Further, it says that who defines these different terms on the basis of which the president of US is impeached. It says that high crimes and misdemeanors has historically encompassed corruption as well as abuse of public trust, and this is as opposed to certain violations of different criminal laws. However, overall, what constitutes a crime with respect to impeachment of a president has to be determined by the majority of the House of Representatives, and whatever the House of Representatives of United States considers as a reason sufficient for impeachment can be said to be a given reason for impeachment. So in this case of Donald Trump, the reasons were abuse of power of the office of president and also obstruction of the working of Congress. So the question is that what was the criteria of impeachment of Donald Trump? It says that his impeachment process basically began from July 25 phone call with Ukraine's newly elected president Volodymyr Zelensky, as he asked Zelensky for a favor. Now it is important to understand this particular favor. Now Donald Trump wanted to discredit his political opposition mainly the Democrats, as Trump wanted Zelensky to carry out an investigative process whereby he could have accused the Democrats of bifurcating Ukraine. And Donald Trump tried to bargain this favor from the newly elected president of Ukraine on the basis of aggression from Russian president on Ukraine. So Democrats argued with respect to impeachment process in the House of Representatives that Donald Trump misused the office of president against his political opposition in United States and effectively tried to discredit US citizens. So it says that Trump wanted the Ukraine government to investigate Democrats in the 2016 election and his potential 2020 rival Joe Biden. So effectively, Trump also wanted to malign Joe Biden, who was his rival for the upcoming presidential election of 2020. And all this was asked as a favor to United States in return for military aid and some money. So all these were charges put on Donald Trump with respect to his impeachment. Now, with respect to impeachment, you must understand that the process of impeachment ends in the House of Representatives. However, if the president has to be removed, then such a proposal must be passed in the Senate by a majority of two-thirds present and voting. So, as of now, the Republicans have a majority in the Senate, so it's very unlikely that President Donald Trump will be overall removed from his office of president. However, on a technical ground, he stands impeached with respect to House of Representatives. So, it highlights that no president has ever been removed as a direct result of impeachment. So effectively, as per the polity of United States, there is a dichotomy between removal and impeachment process. So with respect to this impeachment process, Andrew Johnson in 1868 and Bill Clinton in 1998 were impeached by the House of Representatives. However, they were not removed by the Senate. That is, they were not convicted by the Senate and hence they were not removed from the office of president. However, with respect to Richard Nixon, he resigned before he could be removed from the president's office. So again the question is that how does the process of impeachment works in United States? It says that the impeachment process begins in the House of Representatives, that is the lower house. It further debates and votes on whether to bring charges against the president via approval of an impeachment resolution. And this is done through a simple majority. Further, once the resolution of impeachment of the president is passed by House of Representatives, then a trial is held in the Senate, where the members who have passed the impeachment process or impeachment resolution by simple majority becomes the prosecutors, the senators acts as the jurors, and the entire proceeding is presided over by the Chief Justice of the Supreme Court of United States. So members of House of Representative becomes or acts as the prosecutors, the members of Senate acts as the jurors, and the presiding officer is the Chief Justice of Supreme Court of United States. Now this is a different process with respect to impeachment of Indian President, as the Chief Justice of India is nowhere involved in the entire process of impeachment. Now to convict and remove a president, the Senate must pass this resolution by two-thirds majority. So considering all these aspects, it is very unlikely that President Donald Trump will be removed in the Senate, as in the Senate, the Democrats do not have two-thirds majority which is required to remove President Donald Trump. So in this entire event, it is unlikely that the Senate will pass this resolution by two-thirds majority to remove Donald Trump from his office. However, even if Donald Trump is to be removed in Senate, then as per law of United States, the Vice President of US, Mike Pence, would become the President for the remainder of Trump's term, which ends on 28 January 2021. So after understanding this entire process, let us go through the process of impeachment of Indian President prescribed under Article 61 as well as 62 of the Indian Constitution. And then we'll try to highlight the basic difference with respect to impeachment process of Indian President and that of the US President. So Article 61 talks about procedure for impeachment of the President of India. It says that when a president is to be impeached for violation of the constitution, the charge shall be preferred by either house of the parliament. Whereas with respect to United States, the impeachment process is restricted to the House of Representatives. Further, it says that such a resolution for impeachment has to be passed by a majority of not less than two-thirds of the total membership of the House. Whereas with respect to House of Representatives, it was by simple majority in United States. Another important aspect is that suppose if a charge to impeach the president has been initiated in Lok Sabha, then the investigation shall be carried on by Raj Sabha and vice versa. That is, if the resolution to impeach the president has initiated in the Rajya Sabha, then the investigation shall be carried out in Lok Sabha. So it says that when a charge has been so preferred by either house of the parliament, the other house shall investigate the charge or cause the charge to be investigated, and the president shall have the right to appear and to be represented at such investigation. It further mentions that if, as a result of the investigation, a resolution is passed by a majority of not less than two-thirds of the total membership of the House by which charge was investigated or caused to be investigated, then such resolution shall have the effect of removing the President from his office as from the date on which resolution is so passed. So, this was the point which we mentioned, that is, with respect to the President of India, the entire concept of impeachment also involves removal. Whereas in the case of President of United States, the entire process of impeachment in House of Representative need not mean removal from the office of President, and he can be removed or convicted only if the Senate passes the resolution by two-third majority, that is by two-third members present and voting. So this again becomes a significant difference with respect to impeachment process of Indian President and President of United States. Now another important term to be remembered is that in case a president is impeached, then the new president shall serve for a period of 5 years. However, this is not the case with respect to US. In US, if a president is impeached, then as per law, the vice president becomes the president as per the remainder of the term of the president. So, in case Trump is removed from Senate, then Mike Pence would become the president for the remainder of Trump's term, which ends on 20th January 2021. So overall, these can be said to be the difference with respect to impeachment process of that of President of India on one hand and President of United States on the other hand. So after understanding this process, let us move on to our next news of discussion. The next news appears on page number 10 in the editorial section. It says a duty to publish, limiting RTI responses based on locus standi of the applicants could create a chilling effect. Now, as per this editorial, a petition was filed in the Supreme Court whereby the petition mentioned about implementation of Section 4 of Right to Information Act by all public authorities, and the petition also mentioned about filling of vacancies in states and Central Information Commission, as both these commissions have number of vacancies. Now, Section 4 of the RTI Act calls for proactive and voluntary disclosure of information by public authority. However, this is not observed in most of the cases of public authority. Now, with respect to vacancies in states and Central Information Commission, the Supreme Court has asked the center and states to expedite the process to fill up the vacancy. However, it is with respect to the decision of Supreme Court with respect to locus standi that this editorial does not agree with. Basically, the Chief Justice of India, with respect to right to bring an action, that is locus standi, observed that due to the nature of questions being asked in RTI application has led to paralysis of action, as queries asked are not always in public spirit, and such questions are asked by people who do not have locus standi in the matter regarding the query. That is, those people who are asking these questions have nothing to relate or nothing to do with respect to these questions. So the CJI is observed that the nature of questions asked through RTI information are not always in public spirit. Now, this editorial says that this observance of the Chief Justice of India is difficult to grasp and understand because of Section 6 Clause 2 of RTI Act. Now, Section 6 Clause 2 of the RTI Act says that the applicant need not give any reason for requesting information from public authorities. So effectively, this editorial highlights or argues that because of Section 6 Clause 2 of RTI Act, the concept of locus standi does not come into question because the RTI Act itself says that the applicant need not give reasons for requesting information from public authorities. Further, seeking reason for information by the government or public authorities would defeat the very purpose of the RTI Act itself, as the government would have wider powers to reject information based on the concept of locus standi. And this stand of locus standi to seek information will result in more or maximum denial of information under the RTI Act by public information officers. Further, this concept of locus standi will make RTI more opaque and less transparent. Further, this will help the public authorities to cherry pick only those RTI applications which the government want to answer. And this will overall increase the rejection rate of RTI applications. So the idea overall is not to increase the rejection rate of RTI application, but rather to implement Section 4 of RTI Act with respect to proactive and voluntary disclosure of information by all public authorities. Now, this editorial also highlights that a transparency audit report submitted to the Central Information Commission in November 2018 sought certain feedback from 2092 public authorities under the Central Information Commission, and this was done to evaluate the implementation of Section 4 of the RTI Act. And it is surprising to know that only 40% of the public authorities responded to this particular transparency audit report, where 35% of public authorities fared very poorly or poorly with respect to little transparency in parameters such as organization and functions, budget and program, e-governance, and other information disclosures of public authorities. So, this editorial effectively mentions that it is the duty of the government to ensure that Section 4 of RTI Act is implemented properly with respect to voluntary disclosure of information by all public authorities. And also, the CIC should look into filling up vacancies in state as well as Central Information Commission. Thus, this topic becomes important from the perspective of polity and governance in GS paper 2 and also becomes an important topic with respect to your prelims examination. The next news appears on page number 1. It says, Tribunal reinstates Mistry as Tata Sons executive chairman. Appellate body rules that decision to remove him from the top post was illegal. And the tribunal here is NCLAT, that is National Companies Law Tribunal. And this has been constituted under Companies Act of 2013. Now the NCLAT has reinstated Cyrus Palonji Mistry as executive chairman of Tata Sons. The tribunal further said that resolution passed by Board of Directors on 24th October 2016 to remove Cyrus Mistry as executive chairman of Tata Sons was illegal. So, as per the order of National Company Law Tribunal, Cyrus Mistry is to be reinstated after 4 weeks, during which Tata Sons can appeal against the verdict in the Supreme Court of India. So, in this analysis, let us learn about the NCLAT decision as well as certain basic facts about National Company Law Tribunal. So, in his decision, the NCLAT clarified that Mr. Cyrus Mistry will be reinstated as director of Tata Companies with immediate effect. Further, the tribunal also ordered Ratan Tata and nominee of Tata Trust to desist, that is to avoid taking any decision in advance which requires a majority decision of Board of Directors or in the annual general meeting. Basically, the tribunal ordered Ratan Tata and the nominee of Tata Trust to avoid taking any decision which may affect Mr. Cyrus Mistry. Now, after removing Cyrus Mistry from executive chairman, Tata Sons converted the company from public company to a private company. So the NCLAT also declared this conversion as illegal. So the Tata Sons have been ordered to again become a public company. And on this conversion from public company to private company, the tribunal said that this decision to convert the company as private was prejudicial and oppressive to the minority shareholders, including the Shapoorji Pallonji group. So the NCLAT held that a conversion of public company to private company was illegal. Further, the tribunal also held that for better protection of interest of all stakeholders, the majority stakeholder must also consult the minority group holder or minority stakeholder, which is the Shapoorji Pallonji group. So these are some of the important judgments or decisions of National Company Law Tribunal with respect to reinstating Cyrus Mistry as executive chairman of Tata Sons. Now, with respect to establishment of NCLAT, it says that the National Company Law Tribunal is a quasi-judicial body in India which adjudicates issues relating to Indian companies. And this tribunal, as already mentioned, was established under the Companies Act of 2013. And this was constituted in the year 2016 based on the recommendation of Justice Jain Committee on Law relating to insolvency and winding up of companies. Now, with respect to functions of NCLAT, it says that all proceedings under the Companies Act, including proceedings relating to arbitration, compromise, arrangements, as well as reconstruction and winding up of companies, shall be disposed of by the National Company Law Tribunal. And the National Company Law Tribunal is the adjudicating authority for insolvency resolution process of companies and also for limited liability partnerships under the IBC, that is Insolvency and Bankruptcy Code of 2016. So these again become some of the important facts with respect to our prelims examination. Now, with respect to composition of NCLAT, it says that the bench is chaired by a judicial member who is supposed to be a retired or serving judge of a High Court of India and also has a technical member who is from Indian Corporate Law Service or ICLS cadre. So these can be said to be some of the important aspects with respect to NCLAT. So after a discussion, these forms your practice question for the day. What you can do is to take a pause of 5 seconds. Practice question number 1. It says Citizenship Amendment Act 2019 provides for which of the following? First, it provides Indian citizenship to all minorities of Pakistan, Bangladesh and Afghanistan. No, this is incorrect. Second, violation of provisions by overseas citizens of India card holder. Yes, this is correct as it provides for violation of provisions by overseas citizen of India card holder. So in this, the question was select the correct answer using the code given below. In this, the correct answer is B, that is 2 only. Question number 2. Consider the following statements. First, there has been a significant increase in GST collection in the last 2 quarters. No, this is incorrect as there has been a consistent fall. Second, GST Council has decreased GST rates on state authorized lottery. No, this statement is also incorrect as it has increased the rates to 28% and has made the rate uniform. So the question is which of the statements given above are correct. So the correct answer here is D, that is neither 1 nor 2. Question number 3. It says consider the following statements. Impeachment process of President of United States of America can be initiated in either Senate or House of Representatives. No, this is incorrect as it can be initiated only in the House of Representatives. Second, US President stands impeached if the House of Representatives passes the impeachment resolution by a majority of not less than 2/3 of the membership of the House. No, this is again incorrect as it has to be passed by a simple majority. Third, impeachment process of Indian President can be initiated only in the Rajya Sabha. No, this is again incorrect as it can be initiated in either house of the parliament. So the question is which of the statements given above are correct. So here none of the above are correct. So the correct answer is D. Question number 4. It says consider the following statements about Right to Information Act. First, it does not provide for voluntary disclosure of information by public authorities. It does through section 4. So the statement is incorrect. Second, every application for RTI must disclose reasons for the information sought. No, this is incorrect as section 6 clause 2 says that reasons need not be given with respect to RTI application. So the question is, which of the statements given above are incorrect? So here both the statements are incorrect, so the correct answer is C, that is both 1 and 2. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.